So it's my pleasure today to welcome you to our fifth event that we are hosting in conjunction with the Universidad Diego Portales on the Chilean draft constitution. Today's event will be focused on the indigenous rights, and we're putting them into sort of the international context of indigenous rights in constitutions. Today we have with us Claire Charters, Associate Professor of Law at the University of Auckland and co-director of Aotearoa, New Zealand's Center for Indigenous Peoples and the Law. And Claire, you can correct my pronunciation on that, please. We've got Michael Coyle, Professor of Law at the University of Western Ontario. And Jorge Contesse, he will be actually moderating the conversation. He's Professor of Law at Rutgers University and Adjunct Professor at Universidad Diego Portales. On behalf of the Universidad Diego Portales, we have Matias Guiloff joining us again today. And I would like to please hand over the microphone to him to say a few comments. And Matias is Adjunct Professor at the School of Law at the Universidad Diego Portales. Thank you so much, everybody, for joining us. And Matias, I'll hand it off to you now. Thank you.
Thank you, Marta. Hello to everyone. Very happy to be with you at this time. So I just want to speak very briefly to provide some context or provide the context in which this activity inserts. As you know, Chile currently is undergoing a constituent process. There's a song that says the eyes of the world are watching now, and that's precisely what's happening in Chile. And within that context, the Programa de Derecho Público of Diego Portales University has been doing several activities during the last 2 years to discuss what is happening on this constituent process. Among them, we have, as Marta just said, we have done already this is the fifth of the seminars we have been doing together with the Canadian Council for the Americas. And the idea is to provide a better understanding of this very contested topics that arise during the constituent process. So in this activity in particular, we want to tackle the subject of indigenous rights in the new constitution. And we have this amazing panel that will be hosted by my friend Jorge Contesse, who I pass the word on right now.
Thank you, Matias. Thank you, everyone, for watching this conversation. As both Marta and Matias have said, the goal is to provide some context and some information, but particularly the view from outside on different topics, as Matias was mentioning, that are highly contested and that have elicited significant debate among both constitutional lawyers, but also the general public in Chile. And one of these topics is, of course, the scope of indigenous rights, indigenous people's rights, which is, I would say, just as a way of introducing this topic, one of the key debts, political debts in contemporary Chile, in the sense that since 1990, when the country resumed its democratic regime after the 17-year military dictatorship, indigenous peoples were key in saying, we want you, the government, to advance an agenda that would recognize both our individual and collective rights, that would imply ratifying International Labor Organization Covenant 169, and a number of other measures that were thought at that time, 1989, 1990, that were key to advance the agenda of indigenous people's rights in the country. It's been 30 years, and along Uruguay, Chile is the one Latin American country that has absolute no constitutional recognition to indigenous peoples, even though they amount to up to roughly 13% of the whole population in the country. So to think about these issues, specifically in the context of the constituent process with a proposed text which significantly advances the rights of indigenous or aboriginal peoples, we thought it'd be interesting and important to hear from experts from countries that have made significant progress with a topic that is also highly contested, right? In Canada, in New Zealand, in other places as well. And so to put our, the Chilean situation in a broader context in which we can hear from others and see how much of what we are trying to do here is either in line with what other comparative examples with other countries, other jurisdictions have done, or whether it is true, as many critics of this proposed text say, that the country is moving way too far in advancing what many call an indigenous agenda, right? That it's just going too far, and that giving recognition to indigenous people's rights in the way the proposed text does it, by defining the government, the country, as a plurinational and intercultural country, it could signify ultimately to fraction the country. That's something that we hear often and often. And so let me just start the conversation by asking both of you, Michael and Claire, and then I should also thank you for being here with us today, to provide some general context of what the situation from the perspective of constitutional law. How is it that the Constitution in both in Canada and New Zealand deal with indigenous peoples? We have different examples. We have treaties, we have First Nations, we have the role of the Crown. And so to put this in context, just to start and to kick off the conversation, Claire, I'd like to start with you. The New Zealand example, many people say, here's a country that has done things right. When you go to New Zealand, I've happened to be there a few times, and you hear critics saying, well, we're not doing enough. What's your general view of what New Zealand and how New Zealand has done when it comes to engaging and interacting with indigenous peoples in the country?
Mm-hmm. Well, kia ora, and tēnā koutou katoa. It's a great pleasure to be here. Ko Ngāti Whakau te iwi. So I'm just greeting you and telling you where I'm from and the particular iwi or tribe that I'm from. So thanks so much for that introduction, and thanks so much for having me here. So with respect to Aotearoa New Zealand, the context, I guess, is important, and that's that we don't have a formal written constitution, and that formally, Parliament has absolute power in the sense that it's unfettered by a constitution. It's unfettered by our Te Tiriti or Waitangi, which was the treaty that was signed between Māori and the Crown back in 1840. But that formal situation of no constitutional protections of rights and unfettered legislative and executive power doesn't really capture what happens in reality, and that is that Māori, making up 15-16% approximately of the population, are a very powerful political force, and remain that despite loss of land and despite this lack of recognition of any self-determination, or what we call in Aotearoa as tino rangatiratanga, and discrimination and social disparities. There is a sense that that Māori are the founding or the earliest arrivals of people here that are political in the sense that their views are sought from all the political parties, and especially, excuse me, we have parliamentary seats, so we have guaranteed seats in Parliament. And while that is really important, and we've had these seats in Parliament guaranteed since, well over, I think must be almost 150 years ago now. It's really the political sphere where Māori play a big role. So I would consider Aotearoa to be plurinational, in fact, despite the lack of constitutional recognition as such, in this very unique situation where you don't have a written constitution at all, as such. So Yeah, and the other thing I think, and contextually, is that iwi, or various Māori tribes, do consider themselves as their own self-governing, self-determining peoples, while from the outside it looks like we are all Māori. We are all different and identify differently with our different tribal nations that we come from. So I'll just leave it there for now, but I'm sure that there's lots more that we can say in talking about some of those comparisons.
That's excellent. Thank you so much. Michael, Claire did say something. Even though we do not use the word plurinational, I believe she said, we still consider New Zealand as a plurinational country, which is something that has elicited significant debate in Chile, saying, oh, there are only 2 constitutions in the world that are actually plurinational, in the sense that they recognize the existence of different nations, right? Or indigenous peoples, or aboriginal peoples, or tribes. There are so many different names. And so if we could take that conversation onto Canada, how would you describe the engagement, the interaction, the relationship between the Canadian government, or Canada in general as a country, with its First Nations?
Okay, well, thank you. And thank you to the organizers for inviting me. It's been fascinating learning about the proposed new constitution. There's a big question there. I'll start with plurinationality, because that gives us some context for Canada. Canada was settled on the basis of historical land sharing treaties starting in the 1760s, and a process that's still ongoing today. So in that fundamental sense, Canada has always recognized plurinationality. You don't sign a treaty with the people down the street or the local YMCA. You sign treaties with other peoples. And so in that foundational sense, Canada is obviously plurinational. We also have had this long mythos or idea of 2 founding nations, which ignored Indigenous peoples, but recognized the French Canadians as a founding people. And our Constitution has always provided, I'll call them, well, different rights for the people who live in Quebec. They, for example, use their own system of law, civil law, as opposed to common law. So Canada is plurinational in that sense as well. But coming back to Indigenous peoples, then we've got treaty making, and we've got the fact that our Constitution, which was passed in 1982, or the amendments to our Constitution occurred in 1982, have a special section recognizing and affirming the Aboriginal and treaty rights of Aboriginal peoples in Canada. And so that too specifically recognizes that there are different peoples who have specific rights that other Canadians don't have. And those rights have since been described by the Supreme Court of Canada as intersocietal rights. A treaty, of course, is between societies, but the other Aboriginal rights relating to hunting and fishing, our Supreme Court has said, have come from the meeting of the 2 sets of societies, Indigenous and non-Indigenous. So although Canada's Constitution and even its courts don't use the words or the word plurinational, I think fundamentally its foundational principles in relating to Indigenous peoples are plurinational.
Thank you, Michael. That's so interesting. There's something you mentioned which is also related to this conversation. 2 things I would like to say and ask. One is, many people fear in Chile, in the context of the constituent process, many people fear, some I would say in good faith, some are clearly not acting in good faith in the sense that they know that what they're saying might not be accurate when we look at the text. But if I may take the best version of people's preoccupations, I would say something like this. We've always been a unitary state. And now the convention, the proposed text says, oh, we'll be a plurinational and intercultural state. And then my fear, again, I'm trying to recreate the best version of the criticism, or the concern, I should say, is that the country will be divided, that the country will no longer be this single unit, even though there's at least one key provision in the text that says the state remains as unique, as one, and indivisible. But despite that provision, people say, the notion of recognizing collective rights to nations, to peoples within the territory is antagonist to the notion of keeping the state unitary as a one single unit.
Mm-hmm.
What do you have to say about this, both in the case of New Zealand and also Canada? My understanding is that in one case we have a unitary country, the other one we have a federal system. And so it'd be interesting to hear what is it that prevents, in other words, the country from sort of falling apart, in the sense that so many nations, in the case of New Zealand, of Canada, so many, Maori, Iwi tribes. How is it that the state remains united, politically speaking, and even legally speaking, despite the fact, or with the recognition of different peoples within its territory? Claire.
Kia ora, thanks for that question, Jorge. We definitely have a similar kind of dialogue here, the sphere of, I guess, recognition of Indigenous people's rights or Māori rights, creating a sense of separatism or interfering with the unity of the New Zealand state. However, what I think is hopefully still, although this waxes and wanes a bit, but I think hopefully still is the perspective that Aotearoa New Zealand was established on the basis of Te Tiriti or Waitangi, that it was established as a nation, on a compact between Indigenous nations, various different Indigenous tribes, and the Crown. So there's still very much that sense that that's our foundation as a nation, which is, as you say, plurinational, but it's part of our, I guess, constitutional psyche. So there is an appreciation that there are multiple nations here, and that we came together in agreement to form a unified state. I think also from a Māori perspective, there's very much a sense that for there to be unity, there has to be some recognition of Māori rights. Māori will not feel, I guess, attached to an Aotearoa state unless there's some recognition of our rights based on Te Tiriti or Waitangi, but also to address ongoing discrimination, ongoing socio-economic, I guess, statistics that in which Māori fall at the bottom of in almost every situation. That, I guess, to establish unity, you need to have Māori wanting to be part of the state, and they will only want to be part of a state or come together as a unified state if there's some recognition of their rights based particularly in this foundational constitutional arrangement set up in 1840, which is very prevalent. When we talk about Māori rights, usually we use treaty rights as synonymous with Māori rights. So I think fundamentally that's where we come at it, but certainly we do have the same fears expressed here, particularly as there is ongoing greater attention to how Māori might exercise autonomy and self-government within that unified state.
That's great, thank you. Michael?
Yeah, I want to make a similar point, but perhaps from a different perspective in Canada. So I described how Canada was settled based on treaties, but for the last 140 years or so, say starting around 1875 or so, Canada started to try to impose a unitary model and to assimilate Indigenous peoples, right? They passed an Indian Act limiting the governance powers of Indigenous people. The court stopped enforcing the treaties in any way, even simple hunting and fishing rights. You might have heard the Pope visited Canada recently because of the national embarrassment that was the residential boarding schools where Indigenous children were separated from their families to try to stop them speaking their languages, stop them learning their culture, and help them become good, quote, Christians or good farmers. And that was Canada's experience from about, as I say, 1875 until, let's say, 1980, to pick an arbitrary number. And people realized that idea of trying to ignore and extinguish Indigenous people's distinctiveness and their ability to make decisions for themselves wasn't working. It wasn't working for Indigenous people, but it was also wasn't working for ordinary Canadians. Couldn't say, well, we feel proud to live in a country where Indigenous people don't have clean drinking water, have very high unemployment rates, can't make simple decisions for their own communities that other Canadians can make. So even from and I'm not Indigenous, but from a non-Indigenous perspective, it became very hard to justify, well, what is the purpose of trying to destroy these cultures and to destroy and suppress their laws? And that was part of the pressure around 1982 toward creating a constitution that recognized at least some Indigenous rights. We've got a long way to go before Canada would be in danger of splitting apart because Canada has recognized too many Indigenous rights. And I don't think we're near that point yet. But I also think I work as a mediator in disputes between the state and First Nation communities. So I'm in the middle trying to help them negotiate solutions to their disputes. And in my own experience, what people want is they want the rights to be recognized, to make decisions over their lives, to have a decent life, to be able to pass on their culture. But they're not looking to have their own border controls, their own postage stamps, their own armies. They're not, I mean, you would find some exceptions, but the vast majority of people want to find a way of living together and one that recognizes their own cultural heritage. And as a non-Indigenous person, I don't see why I should feel threatened by that. In fact, to me, that is not only consistent with equality, it's something to celebrate.
If I could ask whether there's never a single event that triggers political or legal developments as the one we are discussing here. But Michael, you were mentioning a little bit of the evolution, and like something happened with non-Indigenous Canadians saying, well, we can't feel proud of this and that. And so maybe you could elaborate a little bit, and Claire, to you, is there something in the sort of historical evolution that you would say, this is the turning point? We were doing things in this way, and then this happened, or this process started to develop, and it ultimately turned the relationship between the government and First Nations or Indigenous peoples, into a different understanding. Is there something that you can point at to say, here's a critical development? This is how the New Zealand Pakeha non-Maori society understood that we needed to do things differently. And then along the lines of what Michael was saying, just to link this back to the legal developments and evolutions that we are discussing.
Kia ora, thanks again for that question. I think in the Aotearoa context and in the New Zealand context, I would certainly think the 60s and 70s were a moment of significant change, actually moving also into the 1980s. And I think maybe we're in a little bit of a moment currently, or we have been in a little bit of a moment now. And I think in the Aotearoa New Zealand context, and probably similarly in terms of timing with other Kansas states, Canada, Australia, and the US, came out of civil rights movement, and you've got the American Indian movement, and all of that influenced what was happening globally. So there was that outside influence. But then internally, while Māori have always claimed tino rangatiratanga, or our self-determination and our own governance and so on, I think there was a moment of sort of national recognition that what had happened here, in terms of taking land, in terms of not honouring the treaty, that there was this social consciousness that came out around that time, pushed especially by Māori, especially by protest, and there's some really interesting, important examples. Often when there's significant political change, it's maybe not random, but it's almost like a coincidence of events or people being in certain places that leads to certain changes. And I think at the time too, there were Māori leadership both within Parliament and outside of Parliament that were highly effective. And as a result of that, we had the establishment of what's called the Waitangi Tribunal, which looks into historical and contemporary breaches of Te Tiriti or Waitangi, which, as I said before, basically means all Māori rights. And that having the Waitangi Tribunal, while its recommendations are not binding, and that is important when I was talking about the earlier sort of constitutional structure of Aotearoa New Zealand, it has been able to document and really look into these breaches of Te Tiriti of Waitangi, and that has had an influence, I think, on the wider national sort of understanding of what's happened here. So, I think there's a variety of internal and external and Māori and national changes that influence particular changes in time. And, there is a sense, I think, there was a sense, or there remains a sense that there's of shame, I think, with what happened here. And New Zealanders do have a sense of, and I think it's sometimes rather optimistic, but do have a sense of Aotearoa being a human rights abiding, liberal, kind, nice states. We have this reputation internationally of being good on Indigenous people's rights, and it's simply just, it doesn't stand up, that reputation or the self-understanding, but it does mean that when there's an appreciation of what's actually happened in terms of loss of land and so on, and wars and so on, that there's a sensitivity there, which I think is really important. Maybe we'll talk about more recent changes as the conversation goes along, but that's at least in our case. Kia ora.
That's great. Sure. Michael, anything to add to what you're referring to?
In Canada too, I suppose it was similarly almost random events that led to a real resurgence in Indigenous rights. One is that our current Prime Minister's father, Pierre Trudeau, proposed to extinguish and eliminate status for Indians, so Indigenous, any special status for Indigenous people in Canada. He thought that the time had come to move on and move past the history. And that caused great indignation from Indigenous peoples that was picked up in public. I think Trudeau was surprised that Indigenous people didn't want to become just like every other Canadian. They wanted to perhaps be a Canadian, but to hold on to their Indigenous status, rights, and heritage. And then it was so that was 1969. And then 13 years later, Canada wanted to repatriate its constitution. At the time, changes had to be made formally by the British Parliament if Canada wanted to change its constitution. And at that time, there was a huge Indigenous push, even in the courts in the UK, that Canada not be allowed to repatriate, to take back its constitution, unless it recognized the promises that had been made in treaties to Indigenous peoples. And Lord Denning at the Court of Appeal in Britain said, "Oh, I have no doubt Canada will honor its commitments to Indigenous peoples." And there was this section guaranteeing Indigenous rights put into the constitution at the last minute. So it had been building for a while, but I think those two actions, the attempt to eliminate Indigenous people's status, all of their rights as distinct people, and the need for Canada to develop, or perceived need to bring home its constitution, both led to this incredible pressure which is ultimately agreed by all of the provincial premiers and the Prime Minister, to recognize Indigenous rights within the Constitution. I suppose one other thing.
I'm sorry, go ahead.
Well, I was just going to add to your question. I mean, I don't know that the person who is making the critique that you described would think this, but I wonder if they think that not recognizing Indigenous cultures, languages, right to make decisions for themselves, to live on their territories, I wonder if they think that is creating unity within Chile.
Right.
Is that a guarantee of unity if we ignore the situation?
Right.
I suspect that it might not, but I'd leave it to those of you.
Right. So again, I'll make the best effort to put this critique in its best light for the sake of the conversation. And so I would say these critics would say, first, well, no, because for so many years we haven't really given any sort of recognition, and this is where we are. We are dealing with lack of recognition. Of course, we have a statute that was passed 30 years ago, and we're dealing with some significant situation of political violence in the south of Chile, which reminds me a little bit of what Claire was referring to, back in the 1970s in New Zealand, to the point in which Mapuche leaders, Mapuche is the main tribe, indigenous people in the country, have been prosecuted under anti-terrorist statutes. And so the notion of this, the most stringent and strictest laws in the country being deployed against indigenous leaders with significant consequences. I want to put this critique in its best light and say, well, some people say, I would have been fine with the proposed constitution recognizing the country or defining the country as a, quote, multicultural country. Mm-hmm. And many people say, like Canada is multicultural. So whenever others say, well, if you think about what plurinationality means, again, the recognition and understanding that there are several nations or indigenous peoples within the territory and the state interact with them, that's really what plurinationality means. And they will come back and say, no, Canada is really a multicultural country. And if we had done so, meaning if we had defined the country as a multicultural state, then we would be okay. But of course, it's not clear what that means if you're not looking at the details. The details what Michael is referring to, right? The recognition of collective rights, self-determination, the ability to make decisions for their own. And so perhaps, Michael, you could comment on this, since you come from Canada, and this is the country that many people say, well, look at Canada. They have been able to do certain things, not because they recognize themselves as plurinational, but multicultural. What do you have to say about that?
I think that they're apples and oranges. I'm happy that Canada is multicultural. And there is respect for different cultures here, parades, etc., many kinds of food, many different languages spoken here, and that is accepted on a basis of equality, and that's a wonderful thing to have. I'm here in Toronto, and it's an exemplar of that. However, that has nothing to do with the status of Indigenous peoples. All of these other cultures, of course, were not original here, including myself. I actually came from Scotland. So I can't make the argument that even though my Scottish culture is worthwhile, that I should have treaty rights, or I and other Scottish immigrants should have a right to govern ourselves. I think that the history is so different that they need to be treated separately, and multiculturalism is wonderful, but it is not a way to respect the fact that other peoples were in this country before Europeans arrived and had their own customs and laws that are worthy of respect. So Canada is both. It's multicultural, but it recognizes rights for Indigenous peoples that go far beyond what other cultures obtain.
Mm-hmm. Mm-hmm. Great. Claire.
Kia ora. So similar, we have similar tensions between recognition of cultural rights compared to, say, recognition of political rights, if we can frame it those ways, or recognition of cultural rights compared to recognition of self-determination or tino rangatiratanga. And on the one hand, the country, and I think the Crown, is more than comfortable recognizing Māori cultural rights. And you think of the All Blacks. I'm not sure if many of you know the All Blacks, but they're our rugby team, and they have a certain place in New Zealand's sort of social and cultural psyche, and they always do a haka, which is like I hate this language, but I'm going to use it given it's an international audience, but like a Māori war dance is how it's often translated. It's not that, but I'll put it that way. Which reflects that New Zealanders as a whole identify with coming from a nation that has this Indigenous cultural difference, and that's what makes New Zealanders different from, say, Australians or Canadians and so on, is that we have this identity that's informed by Māori culture. As mentioned, much harder when it comes to political rights, but as you mentioned, I'm going to mention again, Te Tiriti or Waitangi, that in our founding document, it recognised the political rights of and self-determining rights of Māori as peoples, as iwi being various different peoples. And Māori have never given up that claim or that right to tino rangatiratanga based there. And but the state finds it much harder to accept or recognise those particular rights. I guess the one of the points is, of course, though, that colonisation continues if the colonial state and the colonial state structure continues to impose itself on Māori. When Māori have our own systems of law and governance and so on. So until the state recognises that Māori are independent to some extent, political nations with our own laws and so on, it is continuing colonisation because it's continuing to impose itself and regulate Māori according to its own political imperatives and cultural imperatives. So kind of, I guess there's a perception that colonisation continues until you recognise Māori as independent political units. Bearing in mind, though, that Te Tiriti or Waitangi was really about peoples coming in together and joint governance, and it wasn't about, it was about living together, but also recognition of our own respective authorities in this case.
Right. That's wonderful. Let me just switch gears now and ask you some more specific questions on those ways of engaging with Maori in the case of New Zealand and First Nations in the case of Canada. So let's think about two areas. One is, I would say political participation, but also processes of consultation. And so the ways in which the governments relate and engage and interact with tribes and peoples by way of, Claire was referring to the reserved seats, but other ways, for example, when there are projects that the government wants to develop, and then they need to engage in processes of consultation. I would like both of you to refer to how, in specific, Canada and New Zealand deal with this. And then I'm going to be asking you about legal pluralism, which is another major topic that is highly contested in Chile. The idea being that, as you have seen, the proposed constitution recognizes the legal systems of indigenous peoples. And again, there's a lot of questions, people saying, oh, does this mean that there will be separate and independent sort of judicial systems or legal systems for indigenous peoples who will become privileged when it comes to facing judicial processes compared to Chileans, compared to non-indigenous? So let's start with first processes of both consultation and political participation, and then we'll move to the specific topic of legal pluralism. Michael, would you want to go?
Sure. Well, in terms of political participation, Canada, unlike New Zealand, doesn't have any guaranteed Indigenous seats in its legislatures. There are Indigenous members, but not that many. And in fact, status Indians in Canada didn't get the right even to vote in federal elections until 1960. So there's no special political status within the Canadian legislatures for Indigenous people. On the other hand, we do have a fairly developed set of rules around consultation with Indigenous peoples when a government action or a corporate action appears to be going to interfere with Indigenous people's rights or their interests in resources or land. And in 2004, as I suspect you know, our Supreme Court said that while the final state of Indigenous rights are being crystallized in Canada, and that may take decades, in the meantime, governments in good faith have to sit down with Indigenous peoples when it looks like their potential rights are being interfered with, when an Indigenous group has never signed a treaty and this is on their traditional lands, for example, or if they have signed a treaty and this might affect their abilities to gather resources, et cetera. In both of those cases, the Supreme Court, even though it doesn't say it in our Constitution, said the government, the state, has a duty to consult with the Indigenous community and to listen and, where possible, to accommodate the Indigenous claims. Now, there's no guarantee. The government still has the final say. All they have to do is consult in good faith. So there's no guarantee of an agreement. But we have a lot of experience now in the last 40, well, not 40 years, in the last 20 years in Canada of trying to make that work. When it works, you see agreements to share benefits from mining and other resource developments with the Indigenous peoples and employment opportunities, et cetera. When it doesn't reach agreement, and we can maybe talk later about some of the reasons for that, you could end up with a blockade of a pipeline, et cetera. We don't really have any good dispute resolution mechanisms in Canada. We don't even require mediation, a neutral party to assist them in their discussions, or a neutral view. But we do have, at least now, something that Indigenous people never had before, and that is the right to have formal discussions if there's any significant intrusion into the rights that they believe that they hold. And so that's the law of consultation as it exists in Canada, and it has been a progressive step despite the lack of mainstream official political power elsewhere.
Thank you. Claire, to you.
Thank you. So I've got a few points to make on the first point about participation. I mean, clearly, as we've discussed, we have guaranteed seats in Parliament for Māori, which is currently 7 out of 120. So quite a small proportion, actually, in end effect. And we also have increasingly moves to, and this depends on the certain local areas, but to include seats for Māori on local governance as well, although that's a contentious issue, and as I said, it's sort of slowly growing. I guess what I would say with seats in New Zealand's obviously and often cited for being important in the sense of having these guaranteed seats, but given their number, only 7 out of 120, Māori views can be and have been overridden with respect to Māori rights, and the kind of one of the most talked about or obvious examples was with respect to Māori interests in the foreshore and seabed, when basically the majority passed legislation overturning a court decision that had recognised that Māori might have rights in the foreshore and seabed. So when the nation galvanises behind protecting its own interests compared to Māori rights, the seats are important, but they certainly don't prevent quite serious taking of land and rights today, right? So that's the first thing I would say. In terms of consultation rights, I guess unlike Canada, we don't have this jurisprudence from 2004 onwards that sets out this consultation requirements, consultation rights at a sort of national overarching level. And so where we've got consultation requirements, it's usually in state law, it's usually in, say, our Resource Management Act, there are some consultation requirements there. They haven't been particularly strong, at least in my view, and certainly fall well short of international standards, so free, prior, informed consent, and other provisions in the Declaration on the Rights of Indigenous Peoples. I noted that the language in some of the articles in the new proposed constitution were clearly drawn from the declaration around consultation and so on, but it's very random in Aotearoa. It depends on the particular piece of legislation. But I would say that very recently, in interpreting certain environmental laws, our Supreme Court, which is our highest court, has been, quite progressive in interpreting Māori rights to consultation and the taking into account of Māori perspectives and interests very seriously, to the extent that in a recent case, a claim or an application to do exploratory work for ultimately seabed mining was pushed back on the basis that it didn't sufficiently recognise Māori interests and rights. So the courts have been quite progressive here in this and more recently. But yeah, overall it's a little bit random, and I don't think it's anywhere near what international standards would require on a sort of daily basis, if you like.
Legal pluralism. Before I move to, there's a question in the chat. I want to hear about the experiences in both Canada and New Zealand with legal pluralism. As you've seen, the proposed text, the constitutional text in Chile, recognizes the legal systems of indigenous peoples. It leaves open to further legislation to regulate more specifically what the contours of the spaces of jurisdiction for one and the other will be. And so let's just start with the general. Is this something that exists in Canada? Is this something that exists in New Zealand? How is legal pluralism recognized? What are the ways in which the legal systems of indigenous peoples interact with the non or national legal system? Michael.
It's a great question. It's something that I'm actually currently working on. Canada, of course, is a pluralistic country in the sense that we've always had, it's a federal country. So where I am right now, I'm affected by laws from the province, from down the street, and from Ottawa, and from the city, if you will. So there's several sets of laws that apply there. And as I said, if I were in Quebec, I'd have a completely different set of laws that the courts usually follow apart from the statutes. So our country is based on the idea that different laws can apply on the same territory, and we've been doing it for 150 years, and it leads to lots of court cases, but no crises. People work their way through those things. In terms of recognizing Indigenous laws, we have a much weaker history. There were some very early cases back in 1867, which recognized Cree law of marriage as being valid in the province of Quebec, in the Quebec courts. But generally, even though our Supreme Court of Canada has said that Indigenous customary law is presumed to have continued after Europeans arrived, we haven't seen the Supreme Court of our country expressly recognize a particular Indigenous law and then apply it to something. We're starting to see trial courts do this, but always in the context of disputes within an Indigenous community about whether an election was properly done for the chief or something like that, or whether a customary adoption should be considered valid. So they tend to be within the community. I will say one very positive thing that I hope is paralleled in Chile at some point. I'm thinking about Indigenous laws, is that Canada has only recently started to really investigate what was the nature of Indigenous laws? What are the laws that still are accepted by these communities? How should disputes be resolved in accordance with Indigenous values? What processes should be used? And this is now being taught, that is Indigenous people's laws is now being taught in, I think, virtually every law school in Canada. In our law school, in my law school, it's a mandatory course for all of the law students that they learn about Indigenous ways of legal thinking.
I'm sorry, what's the mandatory course now?
Indigenous law. So you see
in all law schools across the country.
Most of the law schools across the country. And about 4 years ago, the University of Victoria in British Columbia implemented Canada's first Indigenous law degree. So you can get a degree in common law and also a degree in Indigenous laws by taking extra courses in an extra year in thinking about Indigenous law. So at that level of law students, law professors, trial judges, you're starting to see people take Indigenous law very seriously. Now, we have a lot of the questions you asked are really important ones. Well, how would they interact? Would they operate outside of an Indigenous territory? Would they affect non-Indigenous people within the territory? How should disputes between or conflicts between the systems be resolved? Are they treated as a kind of a foreign law in a city in Chile or in Canada, et cetera? Those are things that the course will have to work out. And we're just at the beginning of that process in Canada. So I was actually quite excited to see the recognition of legal pluralism as I don't remember the exact words, but a set of laws of equal status. to the laws of Chile as being an important starting point. And I think if you, that starting point is important because naturally, I suspect if Chile is like Canada and New Zealand, there will be an imbalance of power between the state's institutions and Indigenous institutions, between state governments and state budgets and Indigenous budgets. And so I'm confident that the non-Indigenous governments will be able to negotiate properly to defend, if you will, the state's regime of laws. But to me, looking at it from the outside, I think it's an important proposal that legal pluralism be formally recognized within the country, because that at least gives a chance, a tool for Chile's courts, et cetera, to say, well, why shouldn't this Indigenous law apply within this tribe, et cetera? And it allows you in negotiations with Chilean organizations and governments in negotiation with Indigenous peoples to work out the contours of whose laws should apply when, and are there standards or limitations to each side's sets of laws. But so I don't want to understate the importance of those questions, but at least this proposal sets you off on that course to starting to negotiate that, which I think is an exciting thing.
Great, thank you. Claire.
I'm just trying to scribble down notes and I can't start writing in terms of so okay, I would start with I guess historically the state of New Zealand has considered itself very much monolegal, in line with that kind of understanding of being unitary. There were very rare cases of any recognition of tikanga Māori from, I guess, from the 1870s onwards. But in saying that, tikanga Māori was what we could, that's Māori law, I guess, for Māori law. So Māori law, however, continued to regulate, in fact, lives in many different areas, and all Māori to some extent, and determined, what was the right thing to do and so on. So while they had this formal situation, in reality, tikanga Māori was still regulating a lot, obviously impacted seriously by colonization and by the state enforcing its own monolegal unitary norms on Māori. Now we have, and this is what I was referring to before, and I think in this area now we have somewhat of a renaissance of tikanga Māori. So likewise, we have our New Zealand Legal Education Council has mandated us all to provide education in tikanga Māori across the board. We have, especially in our courts, some quite amazing cases coming out almost on a monthly basis, where there's recognition of tikanga Māori as a system of law, where the Supreme Court will use tikanga Māori to interpret the common law. So that means that the tikanga Māori then becomes applicable to all, as the common law applicable to all. We have had cases recently in our High Court where the courts, and this is in itself problematic, but that the state courts were asked to regulate a dispute effectively between iwi about who had authority over a particular piece of land, and the state stood back and said, look, well, the state court stood back and said, we can't determine this. All we can say is that your law says that, and the other tribe's law says that. So that's deference, I guess, to tikanga Māori. In our treaty settlements process, you have increasingly co-governance of and recognition of legal personhood of particular mountains, forest areas, river, and so on, which means that in that joint regulation, there's great space for tikanga Māori to regulate that. So, I mean, I think that we are becoming increasingly a state where there is legal pluralism, despite formally still our constitution is monolegal. I just want to also address that point, though, that there's a perception that there will be an inequality if there's multiple legal systems in one space. And, I refer back, obviously, to Michael's point of it happens all the time anyway in federal states, right? Like that you're regulated in one. Canada, you've got lots of different laws that are applicable to you. But that particular perception that, say, in criminal law, if tikanga Māori is going to regulate what happens for Māori in response to, say, a criminal case, that might be different and that's problematic. So what's in that context, what's appreciated though too is that Māori, we regulate ourselves differently in those sort of situations, and that in many cases we have better solutions. And this is in a context where New Zealand is the second highest incarcerator of people globally in the world, and of those, 60% roughly of our population, 60% incarcerated are Māori. So there's a perception that this in the criminal area, the state system is just not working, and so maybe we do need some different way overall in thinking about how our criminal law works, but also maybe we do need a criminal legal system that responds particularly to the sort of both the cultural and context of the people who are being incarcerated.
Right.
That might lead to better outcomes, and that's separate from the sort of broader principled idea of you need equality between systems, and if you just apply state criminal law to Māori, then you're just imposing one system that's not theirs, and that's an inequality in and of itself. So this is a clearly, I think you might be able to see as a topic that also I find absolutely fascinating, and is or not just fascinating. It feels like it makes me feel passionate, because I think that it's an important area that we all need to explore and think about some more and progress. And I feel that, as I say, we're in a particular moment in time here where that's happening. There'll be a pushback, of course, but
right.
We're in a moment.
Because we're talking about legal systems, and we have a few more minutes, I'd like to take this question. Someone in the audience asked, we're talking about New Zealand, we're talking about Canada, which are, of course, common law countries. We're discussing this in the context of a constituent process that takes place in a civil law country. And so the question is, quote, how much does the Canadian or New Zealand experience apply in Chile, right? A country with such a different legal tradition, a civil law system. You're talking about court decisions, both in Canada and New Zealand. What do you have to say with what you've seen from the proposed text, with your experience as Canadian and New Zealand lawyer, thinking about these issues? Is it possible to think, many people say, well, why are you talking about New Zealand, Canada, or even the United States, right, with its own federal law system, with Indigenous, the relationships with Native Americans? We're talking about a civil law country in Latin America. We should be comparing to Bolivia and Ecuador and Colombia, not to common law countries. Your thoughts, Michael?
Well, I guess I'm speaking about Canada because I was asked to, but I think the question is an interesting one. I would note that a large part of Canada is governed by civil law, the province of Quebec, and they manage Indigenous rights just fine under our constitution. In Canada's constitution, these Indigenous rights have been defined as kind of an overarching federal law that is distinct from the original common law and the original civil law, for what it's worth. So I don't see the civil law side of it as really affecting the principles that the state is willing to recognize different legal systems within its country. A part of your proposed constitution reminded me of New Caledonia, which is governed by French civil law. And I was in New Caledonia a while ago. And you may know that disputes between Kanak people, civil disputes between the Indigenous people there, are governed by their own customs and laws. And the French courts have had, apparently, according to the people that I met there, no problems enforcing this. And like your proposed constitution, they have an Indigenous assessor who advises the French judge as to what the Kanak law is, and they discuss how it would be applied in the particular case. And the French courts have gone so far as to say, even if the Kanak customary law doesn't quite cover this particular situation, rather than imposing French civil law, we should ask the elders and the Kanak experts, well, how would the underlying principles of the Indigenous law apply here? And that should be applied rather than civil law. So there are undoubtedly other countries which have recognized Indigenous people's rights that use civil law. I can't think of a reason in principle why that would be any more challenging or raise different questions than it does in common law countries like Canada and New Zealand.
Fascinating. Thank you. Claire.
Again, I guess like Michael, I don't want to talk too much about jurisdictions that I'm not so familiar with, and have had little experience of civil law traditions. But I mean, I would make a few general comments, and one is that civil legal systems or civil law jurisdictions or common law jurisdictions are still subject, for example, to the UN Declaration on the Rights of Indigenous Peoples, and how each jurisdiction goes about realizing those rights is, it can be done differently, but there are still those rights that are there, and each jurisdiction or country needs to try and realize those rights in their own different ways. So I'd make that general point. I do wonder whether, well, I suspect that the distinction between a civil law jurisdiction and a common law jurisdiction doesn't matter so much in terms of drafting a constitution. The distinction is more about how the legal system functions in the application of that constitution. At least that's my understanding. So, for example, I would think that, again, I've got to be careful because I've not worked or lived or researched civil law jurisdictions so much, but I would expect that the constitutional rights on the legislature wouldn't be too different in a civil law or a common law jurisdiction. Where you might get differences in terms of how you realize those rights might be around the role of the courts. But even then, I'm not sure that this in practice, as Michael's example with New Caledonia illustrates, I think that there's a whole lot of difference in how judges go about judging in civil law traditions when you have far more sort of or the setting out of norms and this sort of and less room for judges to make their own interpretations or to take law in a certain way. Yeah, I'm not sure that distinction is as great as we might assume it is. So, and certainly I would always say we can learn from one another. I mean, it's fascinating for me to read the Chilean Constitution, thinking about the kind of advice I would give to both Māori and to government about the ideas that we could think about in Aotearoa. I've learned a lot, and one thing I would say is that we're assuming that Indigenous rights, we're all trying to ensure that Indigenous people's rights are protected and honoured and so on, to the extent that hopefully states are going in this upward direction. That's a good thing to help other states then also think about or feel confident about moving towards greater protection, which is part of the reason actually why we're probably sitting in this webinar in a way, to learn from each other and feel confident that the world's not going to end by realizing Indigenous people's rights.
Which is incidentally the question that I had reserved for these last minutes that we are together. I'd like to give you some kind of open space for you to comment on anything that stands out when you read this text. We've mentioned some of those provisions now in the past hour, but this is really an open question. I mean, it's not a question, it's really an open room for you to comment on what you see as particularly striking or interesting, generally speaking. You don't have to be an expert in Chilean constitutional law, but you're expert in Indigenous people's rights. And so from that perspective, what is it that you would comment about this proposed, this draft constitutional text? Claire, I can start with you.
Let's make sure. Oh, yes, I thought I might have muted myself. I guess one, I found it very inspiring. there was lots, as mentioned sort of earlier, I think that we can learn from in Aotearoa from the proposed constitution. I guess one overall comment I would make is it's from where I sit in Aotearoa, it's interesting that there is both kind of a rights element plus a political element. Māori rights in Aotearoa are mainly, I guess, protected. They're not protected always, for sure, as I mentioned, but are mainly protected through the seats that we have in Parliament, because we don't have higher law or higher human rights law or higher Indigenous rights law. And then in Canada, you've kind of got the opposite, where you've got a rights-based constitutional structure for protection of Indigenous people's rights. So then you've got that higher law that does, I guess, bind the legislature and all. But I see in this proposed constitution, you have both, in the sense that there are guaranteed seats in various different places in Congress, and effectively, it seems like in the Senate, you have consultation rights, and you also have formal recognition of Indigenous people's rights, including to self-government and autonomy. So I think that's interesting to me. It's like it's got both elements of the New Zealand kind of constitutional Indigenous rights structure and of the Canadian kind of model of protection of rights in a formal higher law constitution. So I find that interesting. And obviously various different specific points, and we've discussed those, I think, around self-government, autonomy, legal pluralism, lands, territories and resources, which we haven't focused on so much. Water rights are fascinating to me, and so on.
Thank you, Claire. Michael.
Yeah, like Claire, I find this proposed constitution quite inspiring, and perhaps as a reflection of what the person on the question and answer section was asking about civil law. And it seems to me it might reflect a civil law approach to things, speaking in terms of general values and general norms, at least more than Canada's constitution does, which tends to focus, other than the section on Indigenous rights, it's all about very simple liberal individual rights like free speech or the right to vote. So I was very impressed by the commitment to social and economic rights of everyone in Chile, for example, and then in particular to the emphasis on Indigenous culture and language and worldviews, all being referred to as being worthy of respect in the Constitution. And I think that sends an important message, you know, just in the words, in terms of respect for Indigenous peoples. There's so much in here. I think one thing that struck me as very positive is the notion of having negotiations. I don't have the section right in front of me, but about the power of Indigenous territorial autonomies. Is that the term? Mm-hmm. And it's set up that should be negotiated. The idea that there's a provision, this is in 308, that the law shall determine the mechanisms for coordinating the different legal orders, I think is forward thinking. I suppose I'd have a few questions, but they're not criticisms of the draft per se, but they're things that I know that Chileans and their courts and their lawyers and Indigenous communities are going to need to work out. And that's things like, well, the state, I'm looking at 102, the state guarantees the right of Indigenous peoples to their lands, territories, and resources. That's quite similar to what the UN Declaration says, if I remember correctly. But what does that mean? Does that include traditional lands? Or is it something more narrowly defined? I didn't see an answer to that here, but I imagine that if there are proposed resource developments, forestry, mining, etc., on lands that an Indigenous people historically had a relationship with, even if they're not able to live there at the moment, that may become an issue. And I mean, to me, the purpose of a constitution is to set out these general principles, and then the best minds, hopefully in Chile, and people of good faith work out how these things should be addressed. Similarly, I wondered about the various places call for consultations and negotiations. One thing that the Chilean proposed constitution has that Canada does not have is a right to be consulted about proposed legislation that might affect Indigenous peoples. The Canadian courts have specifically stayed away from that, saying, well, if we're passing a new environmental law of general application, we can't be expected to consult Indigenous peoples in this narrow legal way. And so that's quite interesting. But the thing that I would be looking at if this constitution passes is, well, how will those processes of consultation and negotiation be structured? You know, I mentioned earlier, my interest, part of it is in negotiation and mediation. So will Indigenous values be part of the process of negotiation? Will they be respected during a consultation that might affect Indigenous lands or Indigenous resource use? Will there be methods of breaking the impasse that are neutral, that aren't just about going to a court of all non-Indigenous people, but maybe a state or territorial entity will be able to create a bilateral body, at least as an initial appeal body, but that has legitimacy both for Indigenous people, the Indigenous people involved, and the state or the state government involved. So I'll be very interested. I didn't see I wouldn't expect a constitution to provide in detail how negotiation processes should look, but I think that will be important as things move on if the constitution is developed, is approved. And I suppose the last thing that struck me, and I suppose it's very important, and I don't know if you or others on this webinar could speak to this, but I'm curious about whether there is general popular support in Chile for this. You've hinted at some of the criticisms that have been made of some of the Indigenous sections. In Canada, sometimes we've had an experience where most people are not that knowledgeable about Indigenous issues, for example, or there can be certain things in we've had a couple of constitutional referendums that have failed, in part because they were dealing with many issues at once, the national rights of the province of Quebec and changing the Senate and introducing Indigenous rights of self-determination. And they failed to pass for various reasons. And I will be very interested in, I think the process seems very strong of having constituent assembly. I understand the president is Indigenous, but that it was widely representative. And I don't know if you have any comments on whether there's a sense as to whether the proposal has broad public support. But I think it would be wonderful if it does get that kind of support.
Well, thank you. I'm just going to say a couple of things, and then I'd like to invite Matias back to the floor, and Marta, whenever you want to join us, just to address some of the questions. And I would say first, all polls so far suggest that the reject vote is ahead up to 10 points. Some others say four points ahead of the approve vote in September. I would say it's a very personal opinion, but to me, the notion of Indigenous peoples' recognition, strong recognition, plurinationality, and that's one of the reasons why I wanted to ask you about that specific concept, which has elicited so much resistance, to the point that in some cases I would say we are pretty much on the border of racism, which is kind of an elephant in the room here. When we go back to things that have been said for the past century and a half, whenever the government was implementing measures that would affect Indigenous peoples, some of the arguments that we see now are kind of updated arguments that we've seen in the past when the liberal republic was trying to establish itself in the territory. So I guess my answer here is twofold. On the one hand, we don't know what's going to happen with the referendum. And second, much of the unknown, the uncertainties related to the resistance that at least in the elites we've seen towards the idea of this very strong constitutional recognition. And my final point to Michael's questions is the convention, the draft constitutional text has left a lot of stuff open to the further legislature. And this is interesting to the question that was posed in the chat, which is for a civil law country, we kind of, I would say we become a little anxious when we don't see the formal detailed regulations that we would need to feel that, okay, things are in control. And so the notion that much of this stuff is left to the legislature, connected to the idea that comes from the Pinochet constitution, that the legislature, that Congress can be some sort of thread, whereas in reality, many of us see Congress, the power of the legislator, as a guarantee that fundamental rights will be in fact respected and enforced. So how that process will unfold, finally, I would say, because of Chile ratifying ILO 169 in 2008, we have experience with consultation processes, some of them successful, most of them, or some of them unsuccessful, but there is experience. It's not something that is entirely new in the country. And finally, when it comes to lands, there's a key transitory provision in the constitutional draft, which says that the government will have to set up a special task force, a commission that will investigate what happened to land, so that the processes of restitution, whatever long that process takes, and I think it's going to take a long time if this text is approved, to see how those interactions will unfold. Just to give some type of context to the very good questions that Michael, you were posing towards the end. I'd like to just thank both Claire and Michael for this fascinating conversation. We could keep this going on. I know we have other things to do, and I want to give the floor back to Matias and Marta. Thank you very much, Claire. Thank you very much, Michael, for being here with us today.
Thank you.
Thank you, Jorge.
Thank you, Jorge, Claire, and Michael for this amazing panel. So once again, it has become kind of a common issue in all these 5 seminars we've already done. The topic about legal cultures, about how different legal cultures respond to or adapt to different phenomena or different legal demands. So it's fascinating. It's fascinating to see it arise once again, and hope we can continue doing this interesting activities and providing better understanding of these topics that are all around the constituent process in the near future. So having said that, I leave it to Marta.
Thanks so much, Matias, and thank you all. Again, Jorge, many thanks for your great moderation of this panel. Claire and Michael, thank you again, and Matias, and also Domingo Lovera, who's not with us today, but thank you, DP, for our wonderful collaboration on all of these seminars. Please keep your eye out for future events that we'll be hosting on this and other things going on in Chile and the rest of the region. You can always visit our website at ccacanada.com for all of the previous videos of this series, as well as others from on issues across the region. And also that this event video will be available in both the original English audio as well as the interpreted audio in Spanish. We'll have that up as soon as possible, probably by the end of day tomorrow. So keep your eyes out on that. So with that, again, thank you all for being with us today. Look forward to seeing you again, and thank our panelists once again. Thanks so much, everyone. Have a great day.
Thank you.
Thank you, everyone.
Thank you all.
Thank you.
Bye.